Welcome to the AskJunior Judgment Podcast. I'm Sarah Thompson, and joining me today is Michael Chen.
Hello, everyone. We're excited to dive into today's topic.
Today we'll be discussing a landmark case in Indian constitutional law, Bachan Singh versus State of Punjab, decided by the Supreme Court of India in 1980. This case dealt with the constitutionality of the death penalty in India.
That's right, Sarah. This was a hugely significant judgment that examined whether capital punishment violates fundamental rights guaranteed by the Indian Constitution. It's a complex and controversial topic that continues to be debated today.
Absolutely. The main question before the court was whether the death penalty provided under Section 302 of the Indian Penal Code, read with Section 354(3) of the Criminal Procedure Code, was constitutional.
For our listeners who may not be familiar with Indian law, Section 302 of the Indian Penal Code deals with the punishment for murder, which can be either death or life imprisonment. And Section 354(3) of the Criminal Procedure Code states that when the conviction is for an offense punishable with death, the judgment shall state the reasons for the sentence awarded.
That's a great explanation, Michael. The case was heard by a 5-judge Constitution bench of the Supreme Court. The majority judgment, delivered by Justice Sarkaria, ultimately upheld the constitutionality of the death penalty. But there was a powerful dissenting opinion by Justice Bhagwati.
Yes, and it's fascinating to dive into the reasoning on both sides. The majority held that the death penalty does not violate Articles 14, 19, and 21 of the Indian Constitution, which deal with equality before law, freedom of speech and expression, and protection of life and personal liberty.
One of the key arguments made by those challenging the death penalty was that it's arbitrary and unreasonable. They contended that the discretion given to judges in imposing the death sentence was unguided and could lead to arbitrary decisions.
That's right, Sarah. But the majority rejected this argument. They held that the requirement under Section 354(3) to give special reasons for imposing the death penalty provided sufficient guidance to judges. They also pointed to various procedural safeguards in place, like confirmation of the death sentence by the High Court.
The majority also emphasized that the death penalty was to be imposed only in the rarest of rare cases. This rarest of rare doctrine has become a cornerstone of Indian jurisprudence on capital punishment since this judgment.
Interestingly, the court drew on international perspectives as well. They noted that many countries still retain the death penalty, and that Article 6 of the International Covenant on Civil and Political Rights, to which India is a signatory, does not prohibit capital punishment for the most serious crimes.
That's a great point, Michael. The judgment does show how Indian constitutional interpretation is influenced by international human rights norms, even if it doesn't always align with them completely.
Absolutely. Now, let's turn to Justice Bhagwati's dissenting opinion, which makes for fascinating reading. He argued passionately that the death penalty is unconstitutional, violating Articles 14 and 21 of the Constitution.
Yes, Justice Bhagwati's dissent is remarkable for its depth and eloquence. He contended that the death penalty is cruel, inhuman, and degrading punishment that violates human dignity. He also argued that it has not been proved to have any special deterrent effect.
One of Justice Bhagwati's key arguments was that the imposition of the death penalty is arbitrary and freakish. He pointed out that whether a person is sentenced to death often depends on the composition of the bench hearing the case, rather than on objective criteria.
That's right. He gave examples of cases where co-accused in the same crime received different sentences, death for one and life imprisonment for another, simply because their appeals were heard by different benches.
Justice Bhagwati also highlighted the class bias in the imposition of the death penalty, arguing that it's largely the poor and marginalized who end up on death row.
Yes, he quoted several studies and expert opinions to support this point. It's a criticism of capital punishment that continues to be made in many countries, including the United States.
Another interesting aspect of Justice Bhagwati's dissent is his discussion of international trends. He pointed out that many countries had abolished the death penalty, and that the United Nations General Assembly had passed resolutions favoring abolition.
That's true. He argued that these international standards should inform the interpretation of the Indian Constitution, especially given India's commitment to international human rights treaties.
It's worth noting that Justice Bhagwati's view on the relevance of international law to constitutional interpretation has gained more acceptance in Indian jurisprudence in the years since this judgment.
Absolutely. Now, one aspect of this case that I find particularly interesting is the discussion of judicial discretion in sentencing. Both the majority and the dissent grapple with this issue, but come to different conclusions.
Yes, it's a crucial point. The majority felt that judicial discretion, guided by the special reasons requirement and the rarest of rare doctrine, was sufficient to prevent arbitrary imposition of the death penalty.
But Justice Bhagwati argued that this discretion, in the absence of clear legislative guidelines, inevitably leads to arbitrariness. He pointed out that different judges might have different ideas of what constitutes special reasons for imposing death penalty.
It's a dilemma that many legal systems face: how to balance the need for individualized sentencing with the principle of equality before the law.
Exactly. And it's not just an academic debate, it has real consequences for people's lives. Justice Bhagwati gave examples of seemingly inconsistent sentencing decisions to illustrate his point.
One thing that strikes me about this judgment is how it engages with philosophical and moral questions, not just legal ones. Both the majority and the dissent discuss the purposes of punishment, deterrence, retribution, reformation.
Yet it's a great example of how constitutional interpretation often involves grappling with fundamental questions about the nature of justice and the role of the state.
The majority judgment, while upholding the death penalty, does acknowledge the gravity of the issue. Justice Sarkaria writes about the brooding horror of hanging and the need for judges to approach the question with great caution.
That's true. And even though the majority upheld the death penalty, they emphasized that life imprisonment should be the rule and death sentence the exception. This has had a significant impact on how capital cases are decided in India.
Absolutely. It's worth noting that while India retains the death penalty in law, actual executions have become very rare. There have only been a handful of executions in the country since this judgment was delivered in 1980.
That's right, Michael. It's a good reminder that the impact of a Supreme Court judgment isn't just in its final verdict, but in how it shapes legal practice and public discourse going forward.
Definitely. Now, one aspect we haven't touched on yet is the procedural history of this case. It's interesting that it came to the Constitution bench because of a reference made by a smaller bench that was hearing a criminal appeal.
Yes, that's a good point. The smaller bench felt that the constitutional validity of the death penalty needed to be reconsidered, even though it had been upheld in an earlier case, Bachan Singh versus State of UP in 1973.
This willingness to reconsider established precedents is an important feature of constitutional adjudication. As Justice Bhagwati points out in his dissent, on issues of such fundamental importance, the court should be willing to revisit its earlier decisions in light of evolving standards and new arguments.
Absolutely. And it's worth noting that while the majority in Bachan Singh upheld the constitutionality of the death penalty, they did modify the legal position in some ways, particularly by emphasizing the rarest of rare doctrine.
That's true. It's a good example of how constitutional law evolves incrementally, even when there isn't a complete overturning of precedent.
Now, as we wrap up our discussion, I think it's important to emphasize that while this judgment upheld the constitutionality of the death penalty, the debate over capital punishment continues in India and around the world.
Absolutely, Sarah. In fact, there have been several important Supreme Court judgments on the death penalty since Bachan Singh, further refining the principles laid down in this case.
That's right. And there continue to be calls from various quarters for India to abolish the death penalty altogether. This judgment, while settling the constitutional question for now, certainly didn't end the broader societal debate.
Indeed. And I think that's one of the fascinating things about constitutional law, how it intersects with these ongoing social and moral debates. The Bachan Singh judgment, both in its majority opinion and in Justice Bhagwati's powerful dissent, provides a framework for thinking about these issues that continues to be relevant today.
Absolutely, Michael. Well, I think that brings us to the end of our discussion for today. We've covered a lot of ground, from the specific legal arguments in the case to the broader philosophical questions it raises.
We certainly have, Sarah, and I hope our listeners have found it as fascinating as we have. The Bachan Singh case is a great example of the complexity and importance of constitutional adjudication, especially when it comes to issues literally of life and death.
Couldn't agree more, Michael. Thank you to all our listeners for joining us today on the AskJunior Judgment Podcast. We hope you've enjoyed this deep dive into one of the landmark cases in Indian constitutional law.
And we look forward to exploring more fascinating legal issues with you in our future episodes. Until next time, goodbye, everyone.
Goodbye, and thanks for listening.